legislation is the Great Charter, widely considered to be the foundation of the English and U.S. constitutional systems that we all know. Welcome. We're here today to celebrate the touring exhibit, the Magna Carta Enduring Legacy. Next year will be the 800th anniversary of the Magna Carta. This is a collaboration of the American Bar Association and the Library of Congress to present a traveling exhibit to raise awareness about the Magna Carta and celebrate its enduring legacy. This has been quite a feat to bring this here, and I want to give special thanks not only to obviously our platinum sponsors, who you see these same names and same firms whenever something special or necessary comes around. But thank you to all of you, and also Corey Hodak, who was called out kind of unexpectedly today, but she really was the person that did this, and this was a lot of work to bring this here. This is some rare company. The other cities that will have this exhibit are New York, Boston, Chicago, San Diego, Houston, University of Michigan's Law School in Ann Arbor, Atlanta, Philadelphia, and Jacksonville. Quite a testament, I think, to this group of people and to the Chester Bedell Inn of Court and all the platinum sponsors that brought us here. So what I'd like to do is turn this over very quickly to Judge Mahan, who will introduce our guest speaker, our resident, I guess, history buff and law nerd on the Magna Carta, who will tell us about it. And what you'll realize, I'm sure, as Judge Schlesinger tells us a little bit about the history and meaning of this, is that even though we don't realize, just like we're not really aware of the air we're breathing, it's in everything we do. So with that, Judge Mahan.
Good afternoon, and I will be very brief. First, on behalf of the 4th Judicial Circuit, let me welcome all of y'all here. I am not Chief Judge yet. I am only doing this because Judge Moran is out of town. But it's a great honor to welcome you all to our courthouse and to this area. And it's my distinct honor to welcome Judge Schlesinger. I know most of y'all, if not all of you, know Judge Schlesinger very well, but you may not know a little bit about his background. Judge Schlesinger graduated from the Citadel and for undergraduate, and then law school was the University of Richmond. And after that was corporate counsel, served for a period as corporate counsel for Seaboard Coastline Railroad. He was, of course, 16 years as a federal magistrate here, and is now, of course, the U.S. District Judge. And this is one of his huge passions, is the Magna Carta in this exhibit. And I know without the financial backing of the people that came here together to bring this exhibit, and his huge interest in this, and his pushing from his end, that this would not have happened. So with that, I would ask Judge Schlesinger to come up and educate us all.
It's a privilege to have this opportunity to address you this afternoon. Unfortunately, the remarks that I prepared were for about 300 high school students that were supposed to be here earlier in the month but never showed up. And I thought that we were going to have a bunch of them today, so in going back, I'm going to try to make it a little bit shorter and leave out some of the information that you know. I got interested in the Magna Carta many years ago. There was a district judge in Baton Rouge, Louisiana, by the name of Alvin Rubin, and he used to tell prospective jurors the story of Robin Hood and how it fit in with the Magna Carta, and I'd never even heard about this. So I did a little bit of research, and interestingly enough, one of the panels back here talks about the Magna Carta and how after it was signed, the king felt that he couldn't execute Robin Hood because it would violate the Magna Carta. And one of the provisions in the Magna Carta was that people who would infringe upon the rights that are guaranteed therein would be excommunicated. And I guess he wasn't interested in that. In doing some of the research, for those of you that have been involved in jury selections before me, I do go back and tell the history a little bit about the law, going back 4,000 years or so when we had the Code of Hammurabi and then the Justinian Code. And historians tell us that 4,000 years ago, the Egyptians actually used a jury system called the Kenbet. And in trying to find out how they got a cross-section of the community, their juries actually were selected. There were 8 members, 4 from the east side of the Nile and 4 from the west side of the Nile. So I got interested in doing a little bit of this. I mentioned the Code of Hammurabi, the Justinian Code, and then all of us remember that God called Moses to Mount Sinai and gave him the 10 Commandments. And then around 528, when the Western Roman Empire was declining to some extent, Emperor Justinian invented his code that was used basically all around. That was a written code, and you know from our early law school, the English had developed a different system called the common law, where instead of having written statutes, it was the wise judges who decided what the law was, and then that was passed on from time to time. The Magna Carta was actually created along the banks of the Thames River in England in 1215. The anniversary date is going to be June 15th, but I think historians are not sure whether it happened between June 12th or June 15th, the exact date. King John was in Windsor Castle, the one that burned a few years ago, so we know that that castle has been in existence for all that time. And the barons actually kidnapped him and took him to a small plot of land along the Thames River in Runnymede, England. And for those of you that haven't been to Runnymede, I suggest taking a visit there. Historically, there is really nothing to see other than a bronze plaque on the side of the road, the name Runnymede Tavern on the only building that's there, and a gazebo that was given by the American Bar Association and President John F. Kennedy in the early 60s to commemorate this big event. But they took the king from Windsor Castle, brought him out to this plot of land, put the sword to his throat, and he didn't sign the Magna Carta. People couldn't read in those days, most of them. So he just impressed his seal on it, and that became the Great Charter. Now, for those of you that recall the story of Robin Hood, either by film, in my days it was Errol Flynn, but I understand Disney had a newer version, or if you have read the book, Robin and his band of merry men, of course, lived in a hidden camp in Sherwood Forest, and the sheriff of Nottingham spent years trying to capture him, and that was at the behest of Prince John. This was before John became the king. His brother, Richard the Lionhearted, actually was the king from 1179 until roughly 1189. When he died, John became the king. John was not liked as a prince, he wasn't liked as a king. Richard was loved by everybody, but Richard wasn't home to do his duty. He was either off in the Middle East fighting the Crusades, which I think today they're still fighting the same Crusades, and then spent most of his time, almost 10 years worth, in England, in Europe, on the European continent, trying to wrestle the land that now is in Normandy in France for the English. And as a matter of fact, if you go to the city of Les Andelys, France, there's a castle up on a hill that was King Richard's, and it was good enough for King Richard, and actually General Rommel occupied that castle when the Germans conquered that part of France. Well, what happened when John then ascended to the throne, as I mentioned, the barons took him out, actually kidnapped him, and he signed this Magna Carta, which is, as Judge Beverly told you, the Great Charter. These are some of the provisions that the Great Charter has in it. In Clause 39, probably the most famous clause, it reads, and I quote, "No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled or deprived of his standing in any other way nor will we proceed with force against him or send others to do so, except by lawful judgment of his equals or by the law of the land. The 40th clause provides, no one will we sell, no one will we deny or delay the right or justice. The 46th provision required that only people who were learned in the law could become justices, sheriffs, or bailiffs. Now, beginning with the first charter of Virginia, which was written in 1606, and the Mayflower Compact that the Pilgrims wrote up in Massachusetts in 1620, that English system and the liberties that the Magna Carta had granted were transported to the American colonies. William Blackstone, that great English jurist, put it this way. First, the great charters of liberty, which was obtained sword in hand from King John, was for the most part declaratory of the principles grounded the freedom and fundamental laws of England. Afterwards, by statute, the Great Charter was directed to be allowed as the common law. So when those people who immigrated to the United States as colonists, they brought with them certain rights that the Magna Carta had granted to them, birthrights, inheritance rights, and things along those lines. But mainly, what they were trying to do was to impose a barrier between those people in power and who would act arbitrarily and capriciously. This American concept of equal justice and freedom was thwarted, as we know, by the King of Great Britain, and the people in America, few in number but firm in resolve, revolted and adopted the Declaration of Independence and stated in that declaration in 1776 why they were revolting and trying to break away from the mother country. One of the reasons that they specifically stated in there was about the power that the king had over judges in setting their salaries and appointing them. In 1777, the Continental Congress agreed to form a government, but there were weaknesses in that document. The federal government had no power to tax, they had no power to regulate interstate or foreign commerce, and any amendments to the Articles of Confederation required all 13 states to approve it, which was kind of a check on. I'm going to talk about that a little bit more later. In 1785, commissioners were appointed by the states of Maryland and Virginia to try to come up with a compact to regulate commerce on the Potomac River, and the result of that meeting was the 1787 convention at Philadelphia, where the Constitution was drawn up. Now you have to remember that the Constitution set up a new theory of government. Up until that point, most despots and rulers stayed in power through military force, and we were going to try something new, and that was through law and politics, set up a new type of government. Now, the Constitution and the Bill of Rights and the amendments thereto removed from the common politics things that could be oppressive, especially to minorities. Article 3, Section 1 of the Constitution established the federal judiciary, and I don't think I need to go into much detail in that group, but you know, under it there was one Supreme Court and such inferior courts as Congress from time to time would ordain and establish, but it had the hallmark for federal judges serving during good behavior, which basically means if they're rarely impeached or die in office or resign, their jobs are there for life. And as you know, the reason for that was so they wouldn't be beholden to the other two branches of government. And it is, we can talk amongst friends. It is amazing how all of a sudden you wind up with a senator supporting you and the White House submitting your name, and that's the end of the rope. For those of us that were appointed before President Carter, he stopped the practice. The presidents before that used to call a potential nominee the night before to tell them they're going to be nominated and congratulate them and all of that. And I'll never forget Papa Bush. The last thing he told me was, "I've got you this far, you're on your own the rest of the way." Now, James Madison wrote in the Federalist Papers something about government, which I'm going to quote to you in just a minute. But remember, I said that the Articles of Confederation had some flaws in it, and one was it took 13 states to amend the Articles of Confederation. So when you're giving a little talk to some high school students, this is a bit of trivia. Is the United States legal? That is, the Constitution only required 9 states for ratification, yet the Articles of Confederation said it would take 13 to change. So if we change from the Articles of Confederation to the Constitution with only 9 states, somebody should bring a lawsuit suggesting that the whole thing is unconstitutional. This is what James Madison said in the Federalists. "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on the government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and then in the next place oblige it to control themselves. A dependence on the people is no doubt the primary control of the government, but experience has taught mankind the necessity of auxiliary precautions." Now, the U.S. district courts were created in the first Congress. I believe it was about the 20th piece of legislation, the first Judiciary Act in 1789. And there was also an intermediate appellate court. It didn't have a name. U.S. Circuit Courts didn't come into being until later. And the intermediate court consisted of 2 justices from the Supreme Court who were circuit riders and 1 district judge, but not the district judge whose case was on appeal. And it was in that act that the idea of the Supremacy Clause and judicial review came into existence. We know that later on, many judicial scholars have said, if you want to know what the Constitution says, don't read the Constitution, but read the Supreme Court opinions that will tell us what it is. Now, although there are lifetime appointments for Article 3 judges, all federal judges have taken the same oath to follow the law. And I would be foolish if I was to stand up here and tell you that no federal judge has ever consciously or subconsciously ruled his role or her role as authorizing personal policy making. And I think part of that comes from people who don't understand the difference between the term anointed and appointed. Justice Cardozo in the 1930s wrote this: "The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant, roaming at will in pursuit of his own ideals of beauty and goodness. He is to draw his inspiration from consecrated principles." An unnamed judge in Georgia in 1913 wrote the following: "The provisions of the Constitution are the sacred jewels which have come down from our English ancestry, forced from the unwilling hand of a tyrant by the apostles of personal liberty and personal security. They are hallowed by the blood of thousands of struggles and stored away for safekeeping in the casket of our Constitution. It is infidelity to forget them. It's sacrilege to disregard them. It is despotic to trample upon them. They are given as a sacred trust into the keeping of the courts. We should with sleepless vigilance guard these priceless gifts of a free government." So let us today rededicate ourselves to those hallowed words which we find behind us when you visit the display that came to this country from England, that all stem from the document called the Magna Carta. Thank you.
thank you all for coming today. This really is a special moment, especially for those of us who work every day in the law. This exhibit is here through October 27th, so if you have an opportunity, please come and visit and linger. That's today. Today's the 28th.
November
November 7th. November 7th. Excuse me, thank you. You can strike that from the record, Mike. Well, it's going to be here for a couple weeks. So there's a loop, a continuous video loop, takes about 8 minutes. It's very informative, and it takes whatever time you'd like to linger and read each of these panels. It really is fascinating. But when I'm sitting here listening to Judge Schlesinger's remarks, it reminded me of a client that we had at the developer. It was a large local manufacturing facility, and we represented them in some fairly important litigation. So, you know, when you do that, you get to know their business. And I asked the plant manager one time why they were here, and they said, well, you know, this particular industry is located primarily in North America. And I said, why? He said, well, we have natural resources. I said, yeah, but what you need you can find in South America and in Russia and Asia and places else, other places in the world. Now, he's not a lawyer. He was a mechanical engineer that was running this plant. He said, oh, that's true, but here we have the rule of law. He said that when we have a contract with a supplier, we can count on it being enforced. And when the government issues us a permit, we know that it will not be changed for the life of the permit. So when you're asking a company to invest hundreds of millions of dollars over the long haul, we do it here because of the rule of law. And we can trace that back to that meadow outside of London and Runnymede 800 years ago. So thank you all for coming. This is a special event. Please take a little bit of time today or sometime in the next couple of weeks to peruse this, and have a good evening. Thank you.